Case on this morning's docket. That is case number 103776, Continental Western Insurance Company v. Christopher J. Shultz, City of Great Bend, Kansas, and City of Great Bend, Kansas Police Department. Counsel may proceed.
May it please the court. Good morning. My name is Gay Tibbetts, and I'm here to represent Officer Shultz and the City of Great Bend. This is a case about the sufficiency of notice under 12105B, and it's an issue of substantial compliance. There's a couple of, and Justice Nuss, I'd like to reserve 5 minutes for rebuttal.
5 minutes is granted.
Thank you. There are a couple of facts that are important to the discussion of this case. One of them is that there were two accidents that the injured party, his name is Mr. Steinert, I'm not sure that appeared in the briefing, but he was injured in an accident with a deer, and he was working, so he filed a workers' compensation claim. About a week later, he was injured in an accident with Officer Shultz. Again, he was working. Again, he filed a workers' compensation claim. Mr. Steinert received his workers' compensation benefits, and the way that the statute works is if, after a year, he does not sue the tortfeasor, then his negligence claim against Officer Shultz is statutorily assigned to his workers' compensation insurance carrier. In this case, that was Continental Insurance. So that's why we have the parties here that we do. Mr. Steinert did not bring suit against the city or the officer. Claim got statutorily assigned to Continental Insurance Company. They wait almost the whole 2 years. The accident happened on March 30th. March 27th, they send a notice of the injury. And the notice that they send to the city says that what they want to recover is lost wages in the amount of something like $4,500, and then another $15,000, which they term indemnity. That notice, there were some procedural glitches there, but I'm just going to leave that part out. Eventually, they file suit. And in the suit, they say that the damages that they're seeking are that same $19,000. 15 months later, they're at mediation, and apparently it dawns on them that the deer that he hit in the first accident did not have liability insurance. And so they decide that though they had been attributing the damages from the deer accident to that workers' compensation claim, in fact, now they've concluded that the damages from the second accident are what the workers' compensation benefits have been paid for. And so they file a motion just after mediation, and they say since January of 2007, so mediation's in May of 2008, they say since January of 2007 we've been putting the damages in the wrong file, and now we would like to change, and we want to attribute $93,000 of damages to this claim. And the court allows that motion to amend. And at that point, the defendants raise, well, you gave notice of $19,000, and they raise that issue, and that issue continues until eventually.
What impact does the notice that you initially received had the proper police report of the second accident? Does that have any impact on your suggestion that you weren't provided notice that it was really that accident from which the damages flow? My
understanding, Judge, is that proper police report was not in the record on appeal, but that Mr. Butler said that it was included, and there was some indication in the file that perhaps it wasn't. It's just not in the record. Am I saying that that's a deficiency? No, basically I'm focusing on the damages, or the lack of notice of the damages.
So in other words, the city understood which accident was at issue in the case?
Yes, ma'am.
Okay.
They did. Yes, ma'am.
Well, your motion to dismiss is entirely focused on subsection 5 of the statute, which is the amount of damages.
Yes, sir.
So there really isn't any other discussion to be had about the details that were communicated about which accident, so all of that doesn't matter. In Chief Judge Malone's dissent, he talks about the notice being wrong, and then he says, and it was Continental's fault. Is fault an element that we consider in deciding whether you win or not?
I would not have worded it fault. However, when you're deciding substantial compliance, I think that the fact that there that what they identified in the original notice was incorrect at the time that they filed the notice is probably what he meant to encompass by fault. In other words, it wasn't just that there was something that was ambiguous. They basically changed their minds 15 months later. And that, if you think of fault in that they changed their minds, then yes, I do think that that's relevant.
Is it your position that that Continental is just restricted to the $19,000 demand that it originally made and that it can't be increased in the course of litigation?
I would be happy with that decision,
I know you'd be
yes.
happy with it, but
Yes,
is that what the statute requires?
Um,
Because it's really not, I mean, I realize you can win different ways, but that's not what we're talking about here.
Right, I understand. And so if they give a completely wrong amount of damages and that makes their notice incorrect, does that mean that they just didn't comply with the statute at all and they get no damages? Is that your question?
I want to know whether,
Sure.
just take the facts the way they are. They demanded $19,000, and in hindsight you wish you would have taken it, but they've demanded $19,000, and now they want to amend to $228,000. Are they held to the 19?
I don't
and
know
you don't
how,
have an objection?
Right. I don't know how I could argue that I didn't have notice of 19. So it seems to me that they would be held to the 19.
So you believe the statute needs to be read that whatever is demanded in the claim to the municipality becomes the ceiling for plaintiff's recovery?
I want the statute to be read that whatever amount is in the claim, you have correct notice of that amount. Yes, I think that that's reasonable. I just didn't have notice of the claim that they're bringing now, or even of the claim that they amended, which was completely different 15 months afterward. But I don't know how the city wouldn't have had notice of a claim for $19,000.
The other thing that and I don't mean to dominate this, but the other thing that confused me in the file was your original motion to dismiss was premised on the notion that plaintiff needed to go back to the city with the new demand to give them notice under the statute after the litigation had already begun. And then your argument in that motion was the whole purpose of the statute is to give notice so that the city might avoid litigation. And I didn't understand that because you're already in litigation. So how can, in the middle of a court case, you argue that the plaintiff needed to go back to the city and amend its number, and then somehow that was cured? That was your argument. And you're not making that argument now, but I can't figure out why you made the argument you did at the district court.
In all honesty, I didn't make that argument, and honestly, I'm not making that argument now. But I don't think they could have gone back because the statute was run. I mean, there was no way to give new notice that was going to cure the problem that happened back in March of 2007, when actually, I mean, they'd waited for 2 years. They waited until the very end before they filed this incorrect notice.
But are you held to the argument you made in the district court? So now you're making a new argument on appeal.
I don't...
Because you said that this thing could be cured by going back to the city and amending the claim.
I don't think that I'm held to that argument because, honestly, I think, if anything, it was probably a suggestion of ways that things they might have done. But clearly they're not, clearly they gave the wrong notice at the last minute. And there's a couple of things about that notice I don't want us to miss. One is it says it's for indemnity. And what indemnity says to all of us is something's been paid and now you're going to be reimbursed, and it's over. It's done. I mean, there certainly is an implication when you say indemnity that the expenses have ended.
Even in a work comp case that may have ongoing payments?
Well, but, the work comp claim that they were bringing was the one where they step in the shoes of Steinert, the injured party. So really what they're bringing, honestly, is Steinert's injury claim. I mean, it's not an indemnity claim, really. It's a tort claim against my client.
How do you define substantial compliance?
Well, substantial compliance would give my client a way to know what it is, the claim that's come against them, the risk that they're likely seeing. If their complaint had made it clear that there were going to be ongoing medical expenses, or that this was not a final number, or any of the ways that would have given my clients notice, hey, you might eventually be, as they are now, asked to be on the hook for $200 and something thousand, I would think that it would be difficult to argue that was not substantial compliance. But what was here was this indication of indemnity. It was the $19,000. And mind you, now this is over 2 years. So thinking like lawyers, you think, okay, car wreck, $19,000 over a 2-year period. That sounds like kind of a minor event. That does not send a signal to you, oh my goodness, this is going to be several $100,000 you're going to be on the hook. So that's why I would argue that this definitely is not substantial compliance.
Get back to, how do we talk about indemnity and the way the claim was described when your motion to dismiss is limited to subsection 5, which is only about the amount of damages? That's what that provision says.
Right, but
I can understand an argument that says they told us about this or that and it was all wrong, but you pinpointed your basis for dismissal, and so I don't get it.
The notice said medical bills $45.80, and then $15,000 something indemnity for a total of $19,000. So I would say that portion is their description of their damages. I mean that's
But that's in my mind that's subsection 4. That's the extent of the injuries and the description of the injuries. Subsection 5 talks about the amount of the claim, and that's all it says. So it seems to me the issue in the case is $19,000 versus $228,000, and not how it was described or detailed.
I can see how you say that. You would say that, although looking at the motion, looking at the notice. If you were looking at the notice to say, I'm the lawyer for Great Bend, what's my risk here? And you saw $4,500 in medical bills and $15,000 in indemnity, that would say something different to me than just $19,000.
Well, isn't the point of the statute and what we said in the Dodge City implement case is that the important inquiry, and this is talking about all 5 factors, not just one factor, but the important inquiry is, did it put the municipality on notice of the time and place of injury, and whether it had an opportunity to ascertain the character and extent of the injury sustained. Not whether it absolutely told them everything about the nature of the injuries. Did it put you on notice? Did it give you an opportunity? And how did it not do that? An opportunity to investigate what it was.
It's what I just said, which is when you get a claim that over 2 years there's been about less than $5,000 in medical bills, and there's been another $15,000 in indemnity, that sounds like a really small claim.
Did it give you the opportunity to investigate? And that's the point of the notice. And if you had questions about what an indemnity meant, didn't you have the opportunity when you got that notice to ask, what does this mean? Is this the extent of the injuries? That's all the statute is about, not some finite precision, but an opportunity for you to say, we don't know what this means, but we have an opportunity to investigate if we choose to. And it did that, didn't it?
I understand that, but I do think that part of opportunity is what is the magnitude of this claim? How much is the city going to dedicate to investigating it if it's a little tiny claim?
So little tiny claims don't warrant investigation?
I'm sorry?
So little bitty claims don't warrant investigation?
No, I'm not saying they never do, but I am saying, and we all know this, that the magnitude of the claim is one of the things that you take into account when you decide about how much resources you're going to dedicate to investigating it.
Could I have your second point on the notice? You said indemnity was one point you wanted to make on the notice, but you said there were 2 points before you, since you're out of time. Can you give me what the second point was?
I think that it was that there had been 2 years, and that it was a total of $19,000 over that amount. Also, then when there was the amendment, they said, well, we've been attributing the wrong amount since January of 2007. And the amendment, remember, came in May. This notice was in May of 2008, and this notice was in March of 2007. So clearly, January to March of 2007, they had just completely omitted. And then there was the 15-month period before we actually got notice that this was a substantial claim.
Chief, may I have one?
Certainly.
You said that you couldn't really argue against $19,000 in damages was properly noticed up to the city. So would you say that the court had jurisdiction to prosecute a claim for $19,000? And if so, why aren't we really talking about the propriety of a 6215 amendment rather than subject matter jurisdiction?
I'm glad you asked that question, because the subject matter jurisdiction is part of what Judge Arnold Berger mentioned in her concurrence. And here's the problem. So if the law is, if you have an incorrect notice and you discover it, you should put it in your complaint, and then 12, 15 months later you can just move to amend, then you have a complete end run around the notice statute. I mean, there wasn't jurisdiction because the amount of the initial notice was incorrect. There wasn't jurisdiction for the claim that was eventually brought.
There was $19,000 worth of damages in this case.
Yes, sir.
And does the insurance company have to claim for every penny they put out? Why can't they claim just $19,000 of the $200 they paid out?
They could, and they
And then
did
why
give
wasn't
notice.
there jurisdiction for this company to get reimbursed for $19,000 in this action?
Because do you really want the notices to come in and all of them to say $25,000 because later we can amend our claim?
That's a whole different story on the propriety of a amendment to the claim. You know, what we're talking about is the jurisdiction when the case was filed, and whether they could proceed, and whether the remedy, as Justice Miles was asking, is the remedy that the insurance company is stuck with what they asked for in their notice, or do we dismiss the whole thing? That's what we're talking about here on remedy, and to me, you only dismiss if there wasn't jurisdiction. And I can't see why there wasn't jurisdiction if the notice was proper for $19,000 and the company was permitted to sue for just that amount.
There was notice of that amount, and but it was not there was not notice of the claim that we have now. I mean, that's the best I can give you, Judge.
Okay.
So we don't have subject matter jurisdiction over the current claim.
Yes, ma'am.
But if it would revert back to the $19,000, there would be subject matter jurisdiction?
I believe so. The subject matter jurisdiction question is thorny because it's not well defined in the cases, to be perfectly honest. There's some, is it subject matter jurisdiction, is it personal jurisdiction? There's all sorts of different ways of looking at it. And so I think that's the difficult question here.
And I think you can read between that to Judge Malone's dissent almost seems to say that if there's a mistake made in that initial notice, you don't even get subject matter jurisdiction at all. So I understand now, assuming that's what he was saying, that you would disagree with that.
It would be difficult for me to say there wasn't notice of a $19,000 claim.
And, of course, the Court of Appeals has been bouncing around whether this is personal jurisdiction or subject matter jurisdiction. And I know your argument is subject matter jurisdiction, but why? Why don't you, I mean, why are those members of the Court of Appeals that are arguing in the other cases that this is personal jurisdiction, why are they wrong?
Well, in part because I don't find Supreme Court precedent that says that it's personal jurisdiction. And because it looked to me like, at least in one of the more recent opinions, when they said it was personal jurisdiction because of a phrase of if this happens, then only then can you sue the city, and they said, well, that is personal jurisdiction. I thought that was a little bit of a stretch. And also because of the argument that you can waive personal jurisdiction and you can't waive subject matter jurisdiction. And it seems to me that your precedent is pretty clear that there's not a waiver argument in these cases. That's what I found troublesome about those.
Any further questions of counsel? Thank you, counsel.
May it please the court. My name is Todd Butler. I'm attorney for the appellant Continental Western Insurance Company. Just want to make sure, I don't know that it makes a whole lot of difference, but counsel had indicated that it was 15 months between the time that the suit was initially filed and the amendment was made. Actually, the suit was filed on September 6, 2007, and the motion to amend was 8 months later on May 18, 2008. During the course of discovery, at a mediation sessions, actually I was informed for the first time that there were additional damages and that there were ongoing payments to Mr. Lane Steinert for his personal injuries. Continental Western Insurance was the insurance provider for Eagle Enterprises for both accidents that Mr. Steinert had. And Continental Insurance initially paid medical bills and temporary total disability and applied them under the account for the Christopher Shultz accident. For some reason, unbeknownst to me and unexplained on the record at this point in time, there was a change, and the payments made for temporary total disability and for medical bills were then recorded under the Deere accident. So when I received the file, I had a $19,590.77 claim. The file was received by my office in late March 2007, almost 2 years after the accident occurred. In an attempt to comply with 12105B, we sent a demand to the City of Great Bend. That demand had attached to it the police report. I think the record is clear with regards to that, and that was found by the Court of Appeals, but I believe it was in discovery responses that the defendant admitted that it was there. In the 12105B demand,
what does that mean to us? What is the fact that the notice of claim had the police report attached? What does that
it provides do for your place? I'm sorry.
No, what does that do for your position?
It provides a place and location of the accident, which under 12105B, I think, is the second requirement.
But it doesn't address the subsection 5 amount of claim.
No, sir, it does not.
So what you did in your notice of claim, if I understand, is when on the subsection 5 part, where you have the amount of damages, you've stuck in the amount of damages for the Deere claim as opposed to the damages that you had for the auto accident, for the police accident.
No,
is that
sir.
right?
No, sir.
Okay.
Ultimately, jury or trier of fact, if this case is returned, will decide how much of the damages are attributable to the first accident or the second accident. What I reported were the damages under the workers' compensation claim filed by Lane Steinert, known to me at the time, and I believe that counsel was right in her statement. It was approximately January 2008 that this switch occurred, and payments started being applied towards the Deere accident and not the Officer Shultz file. Okay? So the Officer Shultz file, at the time that I filed suit, the only damages that were given to me were the $19,590.07. All payments, temporary total disability and medical payments, were being recorded under the other accident claim.
The police accident claim.
The Deere claim.
So when you're saying the other, that's what I'm trying to get at. So
Deere.
the $19,000 at the time you wrote the letter to the city was money paid for the Deere accident.
No. The
Still
police
not?
accident.
Okay, that's fine.
Everything initially was, my understanding, was applied to the police accident, and then for some reason a switch got hit or whatever. On January 2008, they started applying all payments to the Deere accident.
And
Bob,
did that occur after filing of this case? You said the switch. Did the switch occur after the filing of the case or prior to?
I believe.
I just want when you're talking about the dates.
I believe that it occurred prior.
Okay.
So you could make a good faith claim for the $19,000 in damages in this case.
Yes.
I mean, that really was attributed to this accident.
Yes.
And the question then, I guess, as we were asking Ms. Tibbetts would be whether or not you're entitled to any amount over that.
Yes.
And the reason I asked my question was because of Judge Perrin's opinion, where he concludes at the end that your notice of claim to the city at the time it was made was correct. And when I saw that, I was thinking, well, no, that's the $19,000 that goes to the deer, and so Judge Perrin's wrong because it wasn't the correct amount. But you actually are supporting what Judge Perrin's analysis is, which is your claim at the time you made it was factually correct.
Yes.
Okay.
That's all of the damages that I was given and all the damage that my client was claiming at the time associated with this accident.
And when you say this accident, you mean the second
The
accident?
second accident.
Okay.
It wasn't until at mediation when actually it was counsel for the workers' compensation claim who came as a representative for Continental Western Insurance that I was advised that Mr. Steinert was still receiving temporary total disability and medical treatment. His condition was unresolved.
A procedural question. You filed a motion to amend, which the district court granted, but then the Great Bend almost immediately filed a motion to reconsider that, saying that they had planned to. Was that motion to reconsider ever ruled on by the judge? Or so do we have still an amended petition?
I believe it was denied, and from my recollection. There was no response to the motion to amend, which when the response time had ended, I submitted a proposed order to the court that was approved, and at that point, there was immediately a motion for reconsideration filed. And at the same time, there was another motion filed, and I believe the court took up both motions at the same hearing. And that was the motion filed with regards to, at that time, we made argument with regards to the 12105B Section 5. And the court was, at that time, the district court judge in the transcript, he identified the issue. And the issue here is that damages amount change. Just like in this case, when the suit was filed, when statute of limitations was running, Mr. Steinert was still receiving treatment. He was still receiving medication. He was still unresolved with regards to his injury. He was looking at additional surgeries. That's a constant thing in a lot of personal injury cases where the issues are not resolved. The damage amount may change. And what happens is statutes allow us to request an amount in excess of $75,000. And at some point in time, in my experience, district court judges say we've got to make a determination here and go ahead and proceed and get a ruling on this and finalize your case because we can't keep it open forever. If the defendants have it their way, no unresolved case is going to be able to change. Because if we make a demand for the amount due at the time that we know it, and they continue to receive treatment, or we learn later that they have another injury that was undiagnosed, which causes more surgery, we can't claim those damages.
So a claim of in excess of $75,000, which is what you would put in your petition if you were filing against a non-municipality, would not comport with the notice of claim statute? If you claimed your amount of injuries were over $75,000, that's not sufficient notice?
If I did it in 12105B demand and I said an amount in excess of $75,000, I would think I would start first by saying the known damages at this time are X and Y. And we anticipate a claim will be brought for an amount in excess of $75,000. Because if I just say in excess of $75,000, they're going to argue that it wasn't sufficient. And then what happens if I don't recover an amount in excess of $75,000? Say I claim $55,000, I want to get a jury award for $25,000. Did my demand not give them proper opportunity to investigate? I think it did. But their argument would be that it didn't.
When the notice letter says $19,000 in damages, and in the course of litigation you end up at $228,000, have you given the city in the notice that it's required to have sufficient information about the extent of the injuries? Because the extent of the injuries are $228,000 and you only told them $19,000.
Yeah, that's the language used by this court in the Dodge City implement, whether or not the city or municipality received an opportunity to ascertain the character and extent of the injury sustained. They had an opportunity because a demand was sent. At the time of the demand, we advised them that an action would be brought for negligence of Officer Christopher Shultz, and that Lane Steinert had received injuries to his low back, hip, and legs. And we asked for a specific amount in medical expenses and what we had called indemnity at the time.
And doesn't the specific amount that you asked for, as Ms. Tibbetts characterized, really is typically, when you talk about indemnity and you talk about medical damages, the way it's characterized, at least in your initial notice, seems to imply that that's a fixed finite amount. When you typically look at when you're indemnifying a claim, that, as she characterized I think in most people's minds, that means the amount is set, it's over, and you're seeking to get compensation or reimbursement for that amount expended. That's typically how you would think of that.
Yes.
Isn't that right?
Yes.
And so does that provide, as Justice Biles pointed out, kind of adequate notice of what the claim is about?
It does not give them notice of what the ultimate claim ended up being. It gave them notice of the amount and extent of damages that we were claiming at that time. And the argument is that they had an opportunity to investigate it themselves. And if they choose not to investigate or don't investigate, then that demand letter, the 12105B, is deemed to have been denied after 120 days, which occurred in this case. Once the district court case is filed, and the suit was filed for the exact amount in the demand, I believe that the district court obtained jurisdiction. And at that point in time, all requirements for 12105B have been complied with. We can't put the district court in a situation where they're going to constantly look and see whether or not they have jurisdiction to hear a case or whether or not matters change. I believe that we had cited in our brief the case of Farr, where this court had said that jurisdiction is not a light bulb that we can turn on and off. Once suit was filed for the amount claimed in the demand, game over.
Let me tell you what I'm struggling with, which is Judge Swati's journal entry on this motion to dismiss, because he seems to define substantial compliance as being two elements. One, giving the city ample time to investigate, and making them aware of the claim. And he said both of those things were present. There's also case law from this court, though, that talks about those two elements plus the extent of injury component. And he doesn't talk about that. And I'm concerned that we have to. So do you think there is this third component that we have to look at in this case?
Well, I believe the third component in this case is that the suit was filed for the amount of the demand. And I believe also that at any point in time during the 8 months in which litigation was going on and before the suit was ever amended, the City of Great Bend had the opportunity to make an unconditional tender. I actually drove home from Wichita after the mediation when it was disclosed to everyone at that time that we had additional damages. I drove home thinking, someone's in a car driving to Barton County right now. And so I think that limits this case. to those specific facts. The amount of the demand was the amount known at the time, and the amount that we filed suit for was that same amount.
So you think there's a good faith component in the district court's, and that needs to be in the district court's analysis?
I don't think the statute prescribes a good faith element. I think that once the district court receives jurisdiction on the case, that the requirements of 12105B are done. And
I keep getting back to Judge Malone's notion of fault. And of course, that's a factual finding, and the district court didn't make a factual finding of fault. But that's why I'm asking. Let me ask you one other thing. We've got a Court of Appeals opinion with two different rationales for the outcome, which was that you had substantially complied. Which one do you think is the better law? I realize you win under either, and you'd be happy with either, but which one do you think is the better rationale for us to apply for future cases?
Justice Arnold Berger. She concluded the case was vested at the time that suit was filed. And I think that limits this case, the application of these funds, to a situation that no insurance company is going to want to try to create, because it gives them the opportunity to pay an amount far less than they're going to be they're obligated to.
Counsel, I see you're out of time. Do you have any further presentation?
Oh, yeah.
Any further questions of counsel? Thank you, counsel.
Thank you.
You reserve 5 minutes for rebuttal.
Thank you. So here's my problem with Justice Arnold Berger's idea that once there's jurisdiction, then there's jurisdiction, and it doesn't matter what happens after that, is that in these cases, if we're going to be talking about substantial compliance, you're going to have findings about, for example, and a lot of your cases don't deal with this particular issue. They deal with who the service was made on. Was it made on the clerk? Was it made on someone, the hospital administrator? What's the role of the person who accepted the notice? And so that if Justice Berger is right, then if there appears to be jurisdiction, but you find out later that the service was on someone else, then you can't. It can't be that you can have factual findings later.
But there's a distinction between the circumstance where you didn't have jurisdiction of the $200,000 claim, but you seem to be admitting that there was jurisdiction on the $19,000 claim.
They certainly got notice of the $19,000.
And so there would be a difference in a circumstance where you find out that a fact that was alleged that established jurisdiction was a false fact versus an incorrect or estimated fact. There's a distinction, don't you think?
You're right, Your Honor. There is a distinction there. And one of the things Mr. Butler said is that you could never have a case where someone was continuing to receive benefits, and so the amount of the damages would continue to increase. And I don't think with an appropriate notice that is true. It's just you can't do that in this case because all they notified was that there was this $19,000, and they didn't notify that there were going to be continuing damages. In fact, he pointed out that their allegations of damages was, low back and hip pain, which is probably 90-something% of personal injury car wreck cases. There's not anything in that notice that would indicate that you were going to have a claim of the type that we ended up with here. Also, I just wanted to clarify on when the mistake happened. He was saying January of 2008, but in truth, his motion to amend, which is in the record at 192, says that it happened in January of 2007. So several months before the accident, what happened is that they had decided that the Deere accident was the one that they were going to attribute these damages to. Several months before the notice, is that they'd already made that decision. Then they get to mediation and they're asking for money, and they think, it'd really be better if we asked from this entity that has a liability carrier. And then they say, oh, we didn't mean it 15 months ago. And the 15 months is the time between the notice and the time of the mediation. So that was the 15-month period that I was talking about. In the Dodge City Implement case, they talked about, appropriate notice of damages. In that case, they had noticed that there were $3 million damages, and then that in the case, they actually asked for $3,092,000, and the court said that's not really adequate notice of damages. And so if that's not, then the difference between the $19,000 notice that we received and what the claim truly was, because it really wasn't correct, even at the time that it was given, that truly was the value of the claim. Same thing in Zephyr John. In Zephyr John, there was a notice of $15,000, and then when he tried to sue for $50,000, they said, well, that's just not a proper notice, because you didn't really give notice of the extent of that claim.
Would you agree there would have been substantial compliance under the statute if the demand letter had, under subsection 5, had said, right now we don't know what the damages are, but they're in excess of $75,000?
I think it might have needed to be more specific than that, but if there had been an indication...
How can it be more... Give me an example of how it could be more specific if the damages are ongoing and nobody really knows what's happening here.
To date, there are $25,000 worth of medical, and plaintiff anticipates their damages will be in excess of $75,000. I mean, just that sort of what I would call the catchphrase of damages in excess of $75,000 doesn't seem to me to give notice of what kind of a claim it is, but some kind of an indication that would be specific to the claim as opposed to a generic, I think would be substantial compliance. And an indication, particularly absent in this case, is an indication that damages are ongoing, that there's going to be more, that we should anticipate that this is a claim that will continue. Especially given the timing, that it was 2 years after the accident when we got the notice.
So I'm now struggling with the notion of, because plaintiff specified the damages, basically you would be suspending the district court's ability to amend under 6260 the amount of damages. You could amend for other things, maybe, but...
I would think the court would need to take into account the notice that was given and that this is a particular kind of defendant that requires this kind of notice. And yes, that at the time of amending the amount of the claim, the court would have to have looked at the notice and said, well, did you comply with 105B for this kind of a claim?
Do we have any further questions of counsel? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. The court will take this matter under advisement. We now turn